Welcome back to our channel. Today we are diving into an important topic, understanding the right and obligation of the beneficiary under a demand guarantee or standby letter of credit. This area can be complex, but it is crucial for everyone working in international trade or finance. Let's break it down. The principal right of a beneficiary in this arrangement is pretty straightforward. It is the right to make a demand under the instrument. In other words, they can request payment based on the terms of the guarantee or letter of credit. But it is not all. Beneficiaries often have additional rights and functions too. For example, they may need to present specific documents if the amount payable changes or if the instrument is close to expiring. And importantly, they have the right to approve or reject any amendments to the instrument. We will talk more about amendments and what happens if a beneficiary wants to transfer or assign part of their rights in a future topic. But for now, let's focus on obligations of beneficiaries hold. Obligations of the beneficiary. Interestingly, because demand guarantees and standby letter of credit functions as independent instruments, beneficiaries usually don't have many obligations related to the instrument itself. However, there are exceptions. Occasionally, an instrument may require the beneficiary to pay bank charges associated with the guarantee. But here is an important point. In URDG 758, a standard rule for demand guarantees clarifies that the instructing party, usually the one requesting the guarantee, is primarily responsible for these charges. Even if the instrument explicitly states that beneficiary should pay the charges, the instructing party remains liable if the beneficiary does not pay. So the guarantor, that is typically the bank, is not allowed to insist on payment of charges before honoring a valid demand. More details on this can be found in URDG 758 Article 32 and ISDGP guidelines, which we will be discussing in this video. Abuse of rights. Now let's talk about something crucial. What happens if beneficiary abuses their rights by making an unjustified demand? This could happen if the beneficiary makes a demand they know is not legitimate. Such cases can lead to legal action, like a court injunction, or to block or reject the demand. Let's see them in another terms. Although the principal right of beneficiary is to make a demand under the instrument, the beneficiary may have additional functions under the terms of the instrument, including presentation of one or more documents in relation to the adjustment of amount payable under the instrument or expiry of the instrument. The beneficiary also has the right to approve or reject any amendment of the instrument. We shall deal with amendments in more detail in the coming sections. Sometimes, a beneficiary will want to transfer or assign a part of its rights under the instrument, which we will also discuss in the coming sections. Given the nature of the instrument as an independent guarantee, the beneficiary would not usually have any substantial obligation in relation to the instrument. However, occasionally an instrument may provide for the beneficiary to pay bank charges incurred in connection with the instrument. URDG 758 Article 32 make it clear that the primary responsibility for payment of bank charges is on the instructing party. Even if the demand guarantee incorporating URDG 758 expressly provide that the bank charges to be paid by the beneficiary, the instructing party remains liable to pay the charges. If they are not paid by the beneficiary, the guarantor is not entitled to insist the charges should be paid before it pays the complaint presentation. ISDGP B 26 to 29 provides more information on charges. To sum up, the beneficiaries under a demand guarantee or standby letter of credit have significant rights, but they must exercise them responsibly. Misusing these rights can lead to serious consequences. Now let's see the rights and obligation of the applicant or instructing party in a demand guarantee or standby letter of credit. Understanding this is key if you are involved in international business or finance. So let's break it down. The applicant or instructing party has several primary obligations when they request a demand guarantee or standby letter of credit. This ensures that the instrument functions properly and fairly for everyone involved. First up, the applicant's main duty is to give clear instruction to the guarantor, counter-guarantor or issuer regarding the terms of the instrument. Article 8 of URDG 758 lays out exactly what information should be included in these instructions. By following these guidelines, applicants ensures that there is no ambiguity in the instrument, making it clear for all parties involved. Second, the applicant is responsible for covering any bank charges that apply to the guarantee. This ensures that the bank issuing or processing the guarantee is not left with unpaid fees. Finally, one of the most crucial obligations is reimbursement. The applicant must reimburse or indemnify the guarantor, counter-guarantor or issuer for any payments made to the beneficiary under the instrument. Typically, this reimbursement obligation is included in the application or in a separate facility agreement. An explicit reimbursement clause helps avoid any confusion and ensures legal clarity. In some cases, where this obligation isn't clearly spelled out, certain legal system will employ it. However, to avoid uncertainty, it's always better to include it explicitly. URDG 758 and ISB 98 also touch on reimbursement obligations. Article 1 of URDG 758 refers to the role of the instructing party, while ISB 98 Rule 8.01 specifically states that the applicant must reimburse an issuer that has paid a demand under a complaint presentation. Let's see them in more detail. The primary obligation of the applicant or the instructing party are as follows: to give instruction to the guarantor, counter-guarantor or issuer of the instrument regarding the terms of the instrument. Article 8 of URDG 758 lists the information to be covered in this instruction. Second, to pay such bank charges as may be applicable. Third, to reimburse or indemnify the guarantor, counter-guarantor or issuer of the instrument of the sum that may be paid to the beneficiary under the instrument. The relationship between the applicant, instructing party and the guarantor, counter-guarantor or issuer of the instrument is normally set out in an application or in a more detailed facility agreement. This should include an express obligation on the applicant or instructing party to indemnify the guarantor, counter-guarantor or issuer. If there is no such express obligation for reimbursement, some legal system may imply such as obligation on part of the applicant or instructing party. But to avoid uncertainty on this point, it is much better to include an express reimbursement obligation in the application or facility agreement. To recap, the applicant or instructing party in a demand guarantee or standby letter of credit has three main obligations: provide clear instruction, pay applicable bank charges, and reimburse the guarantor if they make a payment to the beneficiary. Clear agreement and strong documentation make these processes smoother and prevent any potential misunderstandings. Now let's see the rights and obligations of the guarantor in a demand guarantee. We will explore what rights and obligations the guarantor has, whether it's a bank, an organization, or even in some cases an individual. Let's get into it. The guarantor is the primary party that issues the demand guarantee, and it's usually a bank. However, it could be also another organization like a parent company or even a natural person, which is depend on local laws. ISBGP B35 confirms its possibility, though it's important to check your country's law to see if individual or non-banks are allowed to issue demand guarantees. The main obligation of the guarantor is straightforward. They must pay when they receive a complaint demand from the beneficiary. This means that as long as the demand meets the guarantee term, the guarantor is required to honor it. But that's not all. Under Article 22 of URDG 758, the guarantor also has the duty to send a copy of the complaint demand and any related document to the instructing party, which is usually the applicant, without delay. If there is a counter guarantee in place, these documents would go first to the counter guarantor, who then forward them to the instructing party. Now, let's talk about the rights of the guarantor. The primary right, when there is no counter guarantee, is to be reimbursed by the instructing party for payments made to the beneficiary. This reimbursement process is typically outlined in the application form or in a facility increment. However, if the guarantor pays a demand that they should not have paid, perhaps because of the demand did not meet the terms of the guarantee, the instructing party can refuse to reimburse them. This makes it critical for the guarantor to ensure each demand is compliant before making payment. So, what if there is a counter guarantee? In a situation with a counter guarantee, the guarantor can make a complaint demand on the counter guarantor. If everything checks out, they will receive payments from the counter guarantor. Now let's see what is self-issued demand guarantee. Occasionally, the guarantor and applicant are the same party. For example, a company might issue a demand guarantee for its own obligations. URDG 758 recognizes this scenario, which can make it easier for a beneficiary to obtain payment without having to prove a contract breach in court. In these cases, both the guarantor and beneficiary should get a legal advice. This type of arrangement involves two agreements, the contract and the demand guarantee. And it is important that both parties understand how each agreement works, especially given the independence principle that separates them, which means demand guarantee and the underlying contracts are two independent agreements. Now, what if the guarantor pays out under the demand guarantee but believes there was no actual breach of contract? Can they recover the payment through arbitration or litigation? This is a complex issue and often depends on the local law governing the contract and the guarantee. So, before wrapping up the key takeaways, let's see them in more detail. The guarantor is a party that issues the demand guarantee. It is usually a bank, but maybe another organization, such as a parent company issuing a parent company guarantee in the form of a demand guarantee. ISBGP B35 confirms that demand guarantee may also be issued by a natural person, but note that in some countries, national laws and regulation may restrict the ability to issue demand guarantee. The primary obligation of the guarantor is to pay against presentation of the complaint demand. But URDG 758 also imposes other duties on guarantor, such as the duty under Article 22 to transmit without delay a copy of complaint demand and any related document to the instructing party, or if a counter guarantee has been issued, to the counter guarantor for transmission to the instructing party. The principal right of the guarantor, assuming there is no counter guarantee, is to be reimbursed by the instructing party. However, if the guarantor pays a demand that it should not have been paid, the instructing party may refuse to reimburse it. The respective rights of the guarantor and the instructing party will be primarily governed by the terms of the relevant application form or facility agreement. If there is a counter guarantee, the guarantor has the right to present complaint demand under the counter guarantee and to recover payment from the counter guarantor. Occasionally, a party to the contract may issue a demand guarantee in respect of its own obligation under the contract. Here, the applicant and the guarantor are then the same party. The definition of the guarantor in URDG 758 recognizes the possibility of the guarantor issuing a demand guarantee for its own account. The reason for such an arrangement is that the demand guarantee may give a beneficiary a simpler and quicker legal route to obtain payment than having to prove a breach of the contract. The guarantor and beneficiary should each take legal advice before issuing or accepting a demand guarantee where the applicant and guarantor are the same party. There will be two separate arrangements between them, the contract and the guarantee. Both parties need to understand their rights and obligations under the two agreements and the importance of the independence principle. If the guarantor has to pay under the guarantee but consider that there was no breach of the underlying contract, can the guarantor recover the payment through arbitration or litigation? The answer to such question may depend on the local law. So, to summarize, the guarantor in a demand guarantee has the primary obligation to pay a complaint demand and some specific rights, including the right to reimburse from the instructing party. But as on any financial instrument, it's essential for both guarantor and beneficiaries to fully understand the terms and rights and the local laws that may apply. Now let's see the rights and obligations of the counter-guarantor in a demand guarantee. Now, we are exploring a unique role in demand guarantees, the counter-guarantor. If you are new to trade finance, this might sound complex, but we are here to break it down. We will cover the obligation and right of the counter-guarantor and how it fits into a bigger picture. Let's dive in. So, what is a counter-guarantor? In a demand guarantee arrangement, the counter-guarantor is the party that issues a counter-guarantee. This is usually a bank, but it could be also a company, in some cases an individual. The role of the counter-guarantee is key in transactions involving multiple layers of financial support. Primary obligation. A counter-guarantor has one primary obligation, to pay a complaint demand from the guarantor under the terms of the counter-guarantee. Essentially, if the guarantor receives a valid demand, they will turn to the counter-guarantor for payment. This setup ensures that the beneficiary will be paid even the guarantor itself does not have the fund on hand. URDG 758 outlines another important duty for the counter-guarantor. According to Article 22, the counter-guarantor must forward a copy of the complaint demand and any related document to the instructing party without delay. This transparency helps everyone involved stay informed and aligned. Now let's talk about the counter-guarantor's right. The counter-guarantor has the right to reimburse by the instructing party. So, once they make a payment on the complaint demand, they can accept to be reimbursed according to the agreement terms. To sum up, the counter-guarantor is the party that gives a counter-guarantee. Again, this is usually a bank but may also be a company or a natural person. The primary obligation of the counter-guarantee is to pay against presentation of the complaint demand made by the guarantor under the terms of the counter-guarantee. URDG 758 also imposes other duties on the counter-guarantor, such as duty under Article 22 to transmit without delay a copy of complaint demand and any related document to the instructing party. The counter-guarantor has the right to be reimbursed by the instructing party, as discussed earlier, in relation to the obligation of the instructing party. In guarantee which incorporate URDG 758, what is the difference between the applicant and instructing party? Can they be the same company? The answer is URDG 758 defines the applicant as the party indicated in the guarantee as having its obligation under the underlying relationship supported by the guarantee, whereas URDG 758 defines the instructing party as a party who gives instruction to issue a guarantee and is responsible for indemnifying the guarantor. So, if you are wondering what's the difference between applicant and the instructing party, even though they sound similar and they often are the same party, but not always. Under URDG 758, the applicant is the party whose obligations are backed by the guarantee. Meanwhile, the instructing party is the one who gives instruction to the issue of the guarantee and is responsible for indemnifying the guarantor. So, while they are often the same entity, they do have distinct roles in the process. Now let's see the issuer's obligation in standby letter of credit. Now, switching gears a bit, let's briefly touch on the role of the issuer in a standby letter of credit, which is closely related to the demand guarantee process. The issuer is the party responsible for honoring a complaint presentation by the beneficiary. According to ISB 98, Rule 2.01, this is their primary duty to ensuring the beneficiary is paid when terms are met. The issuer also has the obligation to indemnify the confirming bank that has honored the complaint presentation. This relationship ensures that the standby letter of credit functions smoothly even across international borders or complex arrangements. In another word, the issuer is the party which issues the standby letter of credit. The primary obligation of the issuer of the standby letter of credit is to honor a complaint presentation from the beneficiary. The issuer also has an express obligation under ISB 98 Rule 8.01 to indemnify a confirming bank which has honored a complaint presentation. Conversely, the issuer is entitled to be reimbursed by the applicant. Now let's look at the confirming bank's roles in standby letter of credit. A confirming bank may be asked by the issuer to add its confirmation to the standby letter of credit. If the bank agrees, it takes on the obligation to honor a complaint presentation. And if they do pay out, they have the right to be reimbursed by the issuer under ISB 98 Rule 8.01. In other words, the role of confirming bank in standby letter of credit is similar to that of confirming bank in commercial documentary credit. The confirming bank will be requested by the issuer to add its confirmation to the standby letter of credit. If the confirming bank agrees to do so, it assumes the obligation to honor a complaint presentation. If a confirming bank does honor a complaint presentation, it has the right to be reimbursed by the issuer in accordance with ISB 98 Rule 8.01. To sum it all up, the counter-guarantor in a demand guarantee arrangement has the primary duty to pay on a complaint demand, along with the right to reimbursement from the instructing party. They also have an important responsibility to keep communication clear and timely. Understanding the different players like applicant, instructing party, issuer, and confirming bank help clarify how these complex financial instruments work. Now let's see the role of advising party in demand guarantee and standby letter of credit. While this role is less common than in a commercial documentary letter of credit, it's still important in certain transactions. Let's break down what an advising party does, their obligations, and how they add an extra layer of security. So, first things first, what's an advising party? In trade finance, the advising party is typically a bank that helps verify and relay the demand guarantee or standby letter of credit from the guarantor or issuer to the beneficiary. Though it's often a bank, it does not necessarily have to be a bank. When is an advising party used? Now, advising parties are less common with demand guarantees and standby letters of credit than they are with commercial documentary letter of credit. That's because the guarantor or issuer in these cases can usually deliver the instrument directly to the beneficiary. But sometimes, especially when additional security or verification is needed, a second bank is brought into the transaction. In demand guarantees, if there are two banks involved, it's often set up through a counter-guarantee arrangement. For For standby letter of credit, a second bank may act as a confirming bank. But there are cases where an advising party is still used to ensure that the document's authenticity is verified before it reaches to the beneficiary. Obligation of the advising party. Let's talk about the advising party's obligation under URDG 758 Article 10. If a bank or any party advises a demand guarantee, they confirm the beneficiary that they have checked the apparent authenticity of the guarantee. Essentially, they are saying, we believe this document is genuine and it accurately reflects the claims by the guarantor. This step adds a layer of trust to the transaction. In the case of standby letters of credit, ISB 98 Rule 2.04 and 2.05 outline similar procedure for an advisor. By advising the standby letter, the advisor confirms they have checked the authenticity of the message. Whether it is demand guarantee or standby letter of credit, these verification steps are all about protecting the beneficiary from receiving fraudulent or altered document. Now, how does the advising party verify authenticity? If the message is sent by SWIFT, they can simply verify using SWIFT codes. SWIFT is secure and codes are unique to each transaction, making it easy for advising party to confirm the authenticity. But if the message is in another format, like a PDF or a hard copy or a fax, the advising bank should take extra steps. This might include contacting the issuing bank directly to confirm the message's authenticity. These additional steps help prevent the issues with false or altered documents. In other words, the use of advising bank for demand guarantees and standby letter of credit is less common than the commercial documentary letter of credit. In most cases, the guarantor under a demand guarantee or issuer under a standby letter of credit is able to deliver the instrument directly to the beneficiary. In demand guarantee practice, if it is necessary to have two banks in transaction, this will normally be structured by a demand guarantee and a counter guarantee. Likewise, if it is necessary to have two banks in a transaction for a standby letter of credit, this will normally involve a second bank acting as a confirming bank. There are, however, still occasions when demand guarantee or standby letter of credit advised through another bank. URDG 758 Article 10 therefore covers the use of an advising party. Although the advising party will often be a bank, there is no requirement that it should be a bank. A primary obligation of the advising party is that in advising of the guarantee, it signifies to the beneficiary that it has satisfied itself as the apparent authenticity of the guarantee and that the advice accurately reflects the terms and conditions of the guarantee. In standby letter of credit operations, Rule 2.05 and 2.04 of ISB 98 set out the procedure for the nomination of an advisor and the obligation of the advisor. If the advisor proceeds to advise the standby, it signifies that the advisor has checked the apparent authenticity of the message. In the case of messages transmitted by SWIFT, the message can easily be authenticated by reference to the SWIFT code. For messages in any other forms such as hard copy, PDF, fax, the advising bank should take additional steps to check the authenticity, such as by contacting the issuing bank for verification of the messages. So, to wrap up, while the advising party is not always used in demand guarantees or standby letter of credit, they play an essential role when extra verification is needed. Their main job is to ensure that the instrument is authentic and that it accurately reflects the issuer's claim before reaching to the beneficiary. It's all about building trust and security into international transactions. So, that's the end of our today's section. If you found this video useful, don't forget to like, subscribe and hit the notification bell for more insights on trade finance. And stay tuned for our next video where we will be discussing the rules which we have discussed in this topic. Thanks for watching. Stay tuned. Take care. Bye-bye.